Parliamentary Group for Media. We have today a panel discussion, and we have a fantastic panel lined up, and I'll introduce them all in a moment. And we've got a really great session lined up on competition in the media and the value of competition. Before we do that, though, I'm afraid we have to do the AGM. It is a requirement on an annual basis for us to have a couple of minutes where we just formally reconstitute and set ourselves up for the next year, and that is today's quick session. So I am going to formally welcome everybody to the All-Party Parliamentary Group Annual General Meeting. First of all, I have some apologies for absence from Lord Don Foster, from Sir Roger Gale MP, Marion Fellows, Rob Butler and Baroness Bottomley. Can I just check with the Secretariat if we have any additional late apologies for absence? No, that's great. Thank you very much. The purpose of this group, which I just need to very briefly set out, is to provide a forum for the discussion of public policy on the media. It links members of Parliament, of the House of Lords and the House of Commons with those people that have an interest in the sector, and principal reason is to facilitate the discussion of public policy in this area. The next stage that I have to go through to is to elect officers, and I have indicated to the Secretariat that I'm willing to continue as the chair, but I am required to ask if anybody else wants to nominate themselves to become the chair. If anybody does, please say now, and we can go through the process of electing a chair. On the basis that I haven't had anything, can I therefore take it that members are happy that I continue as the chair? Given that nobody has said no, I will proceed on that basis, and we will move to the role of vice chair, and I have a number of vice chairs have indicated that they would like to continue in those roles. Baroness Bottomley, Sir Roger Gale, Mark Pritchard MP, Baroness Bonham Carter, Sir Peter Bottomley MP, Dr. Lisa Cameron MP, Lord Foster of Bath, Lord Burt, Alan Cairns MP, Mark Logan MP, Alex Davis-Jones MP, Rosie Cooper MP, Christine Jardine MP, Owen Thompson MP, Jamie Stone MP, Lord Cromwell, Lord Inglewood, Lord Dykes and Lord Strathcarron all indicated that they would like to take up a position of vice chair on the APPG. Can I just check with the Secretariat and others present if there's anybody else that wishes to be included in one of the officer positions for the APPG? No. Okay, that's fine. On that basis, providing everybody is happy, we will accept the chairs, vice chairs, and David Lipsey, I think, is indicating that, is that right? Would like to become a vice chair as well. Double check that. Yeah, okay, and the other two things that I need to indicate are around the annual report and the financial statement. I will ask the Secretariat to publish those in the chat box. There'll be links which you're welcome to look at. Then report details what we've been doing over the last 12 months. And there is also a link to the financial statement which the Secretariat has provided, which we will log with the registrar in the House of Commons. On that basis, unless anybody has any other business related to the AGM, I will close the meeting. That is the AGM completed. There we go. Literally 5 minutes, all done. Thank you very much indeed. Let's push on with the APPG meeting. And I have to start with a couple of housekeeping points. First, if I can ask you to keep your microphones on mute unless you are speaking, and direct questions through the written chat function, which we will try and pick up as we get towards the end of the session. and we'll try and make sure that any questions that are put in there are directed to the right people, so that we get a good response for people when asking questions. We're also pre-recording the event. A number of colleagues have indicated that they can't actually be here today, but because of the subject matter and the relevance at the moment, they'd like to watch the APPG back. So we will make that available to colleagues that have asked for that as well. Let me just sort of set out the background to this session. We have today a session really focused on unleashing innovation, and a question that we, I suppose, want to ask today: does competition online matter for UK media? Last year, the government consulted on its proposals for a new pro-competition regime for digital markets, and they've been seeking feedback on the approach to pro-competition interventions. We have a panel today that I think will be able to really talk about this with great experience, and I hope to explore why the government is proposing reforms to the UK competition framework, the creation of the digital market unit within the Competition and Markets Authority, and what that will actually mean for the media sector. Let me introduce panelists to you. You can probably already see them on the screen. Dr. Andrea Coscelli is with us. He is the Chief Exec of the Competition and Markets Authority, been in post since 2016, and we'll come and talk to Andrea in a second and get a little bit more insight from him, given that the Digital Markets Unit sits within his framework. Also very pleased to welcome Baroness Dido Harding, who's a member of the House of Lords Communication and Digital Committee, Dr. Christina Cafara, who's a senior consultant to the company Charles Rivers Associates and honorary professor at the University College London. Really looking forward to her perspective, particularly given her involvement in this area of policy. Matt Rogerson is the Director of Public Policy at the Guardian Media Group, and Paul Oldfield is the Controller of Policy at the BBC. A really fantastic panel, looking forward to hearing from them as we go through the session. I'm going to come first to Andrea from the Competition and Markets Authority. And perhaps, Andrea, if I can ask you just to open the session with your thoughts on the competition reform and the work of the Digital Markets Task Force, and an update on the Digital Markets Unit, and what you think it will actually mean for the UK media sector.
Great, Andy, thank you very much. So let me just make a few points. So, and apologies for my voice, but I'm emerging from COVID. So the first point is, in many ways, we shouldn't be here. You know, we are spending a lot of time now thinking about regulation, which we know is going to be complicated to implement and enforce because we don't have enough competition. So if you look particularly at Google and Facebook, they were allowed 10, 15 years ago to buy a number of companies. At the time, the global agencies looking at those acquisitions decided that given the uncertainty, the complexity of these markets, they should give the benefit of the doubt to these companies. And obviously, history has shown that that wasn't the right judgment. Interestingly, in the US, there are lawsuits now Christine is involved in some of those, trying to reverse some of these acquisitions, so essentially to break up, particularly on the Facebook side, their acquisitions of Instagram and WhatsApp. But these are, you know, very tough lawsuits. They are a bit on a slow lane procedurally. They're going to now go to trial, I think, at the end of 2023, early 2024. So, you know, who knows what's going to happen there. So in many ways, I think it's important for people to bear in mind that regulation is a bit of a plan B in this space, because we know it's going to be, you know, complicated and in many ways not ideal. But the reality on the ground for people like me and my fellow agency leaders globally is that there are lots of complaints coming to us pretty much on a daily basis from businesses, and lots of British businesses are writing to us, telling us that they are really struggling, that the imbalance of market power between some of these platforms and them is very, very significant. Their whole businesses are relying, in many cases, on a single player. 70–80% of their revenues happen through a particular marketplace. And it's it's really hard, to invest, to get investment, and to grow in that context. So we need to have a setup which is fairer, and where essentially there is more of a level playing field. We should not allow this platform essentially to decide, what to do without any kind of constraints. On the existing legal powers, we have competition powers and consumer protection powers across the general economy. We have many cases that we are doing, and the same is happening in the European Union, in Australia, in the US. But these cases take years. They're very complicated. We end up with very substantial litigation, and to be honest, the results are just not good enough. So if I talk to a CEO of a small business, I can't tell them that this particular process is going to deliver what they need. It's just too slow and too uncertain. So that's why we need something else. That something else has to come from government and parliament, because we just don't have the right legal powers at the moment. So that's a consultation from last summer. It's based on a lot of work we have done as part of this digital task force. We work very closely with Ofcom, the FCA, and Ofgem. We try to take advantage of all the learnings among regulators in this country, and of which there is a lot about process. I mean, a lot of it is about processes where you balance, rights of defense, proper rights of defense, independence of the judiciary, but with proper timetables, with deadlines, with the need that things need to happen and you need to move on. So I'm quite confident that in terms of the substance, what is in that consultation, which is essentially the idea that just a handful of very large platforms will have this special regulatory regime applied to them. There will be a code of conduct which will constrain some of their commercial behaviors, and there will be the ability for the regulator, for this digital markets unit, to also have specific pro-competitive interventions to try to create more competition over time. I think it's the right recipe, and I think this has now been stress tested by many people discussing it globally, and I think there's quite a lot of consensus that it's the right recipe. Interestingly, as some of you know, in Europe, the DMA, which is a bit the equivalent of this, is progressing very quickly, probably more quickly than many people expected, and potentially there could be a final agreement today or early next month. So that's a very useful and relevant data point for us as well, because clearly the platforms will have to spend quite a lot of money and time on compliance, changing a number of their processes. And so what happens in Europe will have an impact, I think, in the UK debate. The architecture of this essentially is that there are three levels. So one level is the primary legislation, which is about the principles and giving them legal authority to the regulator. The intermediate level is detailed guidance, which will be produced by us as the regulator. And then there is enforcement of it. And again, it's a tried and tested approach. It's the way we set up financial services regulation, energy regulation, telecoms regulation, and it works. Again, there are discussions about lots of specific issues, but I think the infrastructure works. So I'm personally very keen that we get on with it, because even after the legislation passes, there is a lot of work still to do on guidance and then enforcement. So, at the moment, we're still years away from an impact of this legislation, because all these things need to happen. As I said, we are working quite hard on our existing powers. We're trying to do as much as we can. We had a big discussion yesterday on our board, again, about digital priorities, how many cases we're going to do in the next few months. But I think it's important for people on this call to understand that the current cases with the current legislation are just costly and expensive exercises for us. So there is just a limit on the number we can do in parallel. And a lot of the rationale behind this legislation is really to speed things up, to make us more effective. So essentially, with the same amount of money, same amount of taxpayers' money, just to achieve more. The last 2 points I want to make. One is on media specifically. Essentially, I mean, if you think commercially, where the pressures are on publishers today, I mean, obviously pressures are very significant, and mainly because a lot of the advertising revenues have kind of moved from them to particularly Google and Facebook. there are three sort of buckets in terms of what we're doing. So one is the just trying to police what's happening on ad tech and privacy. So we had this fairly big case against Google on the privacy sandbox, which is an area where Google, in many ways for good reasons, was trying to increase privacy, but had the potential detrimental impact on the revenues for publishers and competitors. And we have now agreed a very detailed oversight process with Google, with a fairly important role for us using our legal powers. And Google actually is then going to apply globally the agreement with the CMA. The second one is the whole supply chain of what's called ad tech, which is essentially the whole sale and purchase of ads online, where Google plays a very significant role. There is a big case in the US, again, where Christine is involved, which was brought by the US states, led by Texas. And as part of that process, quite a lot of information came out, which worried us and others. And so last week, we launched a formal investigation on that together with the European Commission. So at the moment, basically, on that kind of set of global agreements, you have quite a lot happening in the US, and then now this activity in Europe. But the third area is the sort of payment for news part, where essentially today we don't have really legal powers to do anything particularly useful there. And the legal powers have become available in Australia and France, as most people know, through new legislation. So that's an area where we have produced some detailed advice to DCMS. We delivered it to DCMS in November. And so we understand that advice will be published hopefully shortly as part of the response to the consultation by government. And the final point is merger control, which is an area where there's clearly quite a lot of lobbying activity against any changes. We said in our advice that we think we need enhanced powers to deal with further acquisitions by these very large platforms. And then again, it's going to be for government to decide whether to give us those powers. We blocked an acquisition by Facebook of a company called Giphy last year, and we're going to be in court next month facing a fairly strong appeal. There are lots of lawyers acting for Facebook, lots of third parties now intervene. And I think it just shows how hard it is to actually achieve results with our existing powers. I mean, we're pretty confident about our case, but again, it shows the amount of time and effort we need to spend in the current setup. So that's what I wanted to say by way of introduction. I'm sure there will be other questions as we progress.
Andrea, thank you very much. Can I just sort of pick up on one point you made there? And you talked about pro-competitive interventions. What might that look like? What would you view as, and I appreciate it's a very broad question, but what is a pro-competitive intervention that you'd like to take?
So we have provide a number of examples like interoperability or access to data. So one of the issues is, if you think about Facebook, they have survived quite a few serious scandals. And one of the reasons is people and businesses would say, well, I have a real problem now with Facebook, but where can I go? All my customers are on Facebook, all of my friends and family are on Facebook. And so interoperability would allow potentially competing platforms to access what is posted on Facebook, so that it would be easier for you to move to a different platform, but still be able to interact with your customers and families and friends. And that's, if you think about, telecoms or other areas, regulators have implemented this type of remedies in the past. And that's the reason why we managed to inject competition in some of these network industries in the past.
Okay, thank you very much. If you want to ask a question to Andrea on any of the issues that he's just touched on, or maybe something that he hasn't, please pop it into the chat box, and we'll come back to some more questions in a second. If I can turn to Christina. Christina, you work across many countries in your practice at CRA. What's your assessment of where things are with the proposed reform to digital and a competition in the UK? How do you think this compares with regulatory developments in other markets? I mean, you touched on, I think, a little bit earlier that Andrea touched on progress in Europe. Where are we compared to other markets?
Thank you so much. Andy, and thank you for having me here. Apologies too for my voice. Like Andrea, I'm also emerging from COVID, but getting better. So I think it is fair to say that the UK has been unquestionably the first mover in this space. Very much with the Furman report as early as 2019, and then with the DMU project, which really set it apart as a pragmatic solution that recognized different business models cannot be dealt with in a uniform way, cannot be dealt with in the same manner. So if you think about it, if you say to someone, do not self-preference, when you have very different business models in front of you, are now funded, device funded, etc., the idea of do not self-preference is not exactly equivalent. So the notion that the UK pursued, the project that the UK has pursued with the DMU, which essentially recognizes these differences and really anticipates the creation of codes of conduct that are specific to the different business models. So you, Apple, do this, you, Amazon, do this, you, Google, do this, is a very good way to go about it, and is being recognized generally as being very much an appropriate approach. Now, the European project started a little bit behind this. And in fact, as Andrea alluded to, it's coming to a close, I think, very likely today. We're going to have a law. Today is the final trilogue, as it is known, the triangulation between the European Council, the European Commission, and the Parliament. This was put together really in record time, having started in late 2020. But now, with strong leadership from the European Parliament, in less than a year and a half, we're seeing the project being converted into law, crushed through in less than a year and a half. And this is remarkable. It is also a sign of weakness in some sense, because the reality is that what motivated this effort, and Andrea also alluded to this, is a strong sense that enforcement at the European level against these platforms has failed. We have had cases going on for 10 years, pretty much, before the European Commission against Google. They have achieved perfectly nothing. We have cases against Amazon, against Apple, that have been trundling along for 5-6 years, and they are looking nowhere near to come to any solution, conclusion, resolution, outcome. So the notion that we are all kind of now pivoting to regulation is in some sense a response to this sense of impotence. And the Parliament has really taken up this baton to pursue this fight. Will this succeed? I think I see two related issues here. One is, unlike the UK, which has got this idea of effectively model-specific, company-specific codes of conduct, the European model is more general. So thou shalt not, thou shalt. But of course, this is still incredibly vague, and it is also vague in multiple ways. One, who is going to be in charge of implementing all of this? While in the UK, there is at least a project of DMU, in Europe, it isn't even clear. There is a notion that it will be DG Competition, perhaps with DG Connect. But what is the role of the member states? They're all agitating because they, of course, continue to say, but what are we? Why are we not given a role, at least in the monitoring, in the implementation? This is going to be a very difficult piece, as well as the resources. The bill at the moment, it has 20 people, growing to 80 in 5 years, doing all of this. So it is something which appears on paper, at least, as something which is, while a great effort, I'm not entirely clear that it will deliver. And frankly, the companies themselves are not particularly scared. I mean, because when you have a set of provision that says, you shall refrain from refusing access. Okay, so tell me what I need to do. What's your guidance? Access to whom? Under what terms? What am I getting paid? What are the limits? I'm going to sit back, send me a fax when I'll come and talk to you. So at the moment, it is a great effort, but I'm not clear that it will proceed to deliver quite as much as people kind of say, because it is less well designed than the UK was originally.
So, Christina, can I just on that point then, I mean, well, what is the solution then? If the response from the big tech companies is, as you say, how do we tackle these issues? Are we on the right track?
Well, I mean, there is no question that, of course, antitrust cannot do everything. Antitrust, as Andrea described, is expensive, is resource intensive, is slow, because, of course, companies inevitably also game the system incessantly, trying to claim right of defense, want another 6 months to answer this request for information because it is onerous. So the whole thing gets elongated incredibly. Regulation has got to be an answer, but I think that an approach that was closer to the UK, in which you actually did give companies direct guidance as to what they specifically should do, as I continue to say, you say to people, thou shalt not self-preference. Half of them will look at the room and say, me? I don't self-preference. What do you mean? I don't do it. So please explain. I can sit back for another year until you just kind of come and find me and tell me what self-preference you mean, and perhaps put a gun to my head. But at the moment, I got to do perfectly nothing. I will just pay my expensive lawyers in Brussels to do a compliance report, which is going to be thick. There are going to be 20 people sitting there with 40 compliance reports, each 100 pages, and you will not know what to do. So this is the kind of way in which the companies are.
Thank you. That's very helpful.
If I may.
Yeah.
Sorry,
okay.
Is that the US is super important here. I mean, we're not going to be able to do anything, just I think not very much as a European effort. The US is super important. What's going to happen there remains to be seen. There's been, as you all know, a major bipartisan effort. I mean, not only on the antitrust enforcement side, of course, but on the legislation. Motivations are very different. The Democrats think that what is a problem is market power because economic power begets political power, and that's a problem. The Republicans really care about bias against conservatives. And so these two have come together somehow. We have a raft of proposals, including on ad tech that Andrea was alluding to, break up Google into pieces, Google ad tech, because of course there is inherent conflict of interest. The real question there is if in the next 2 months we will see action or not, because there is a window of legislation for the next 2 months, after which the legislative season ends, everybody goes into midterm elections, and this window is lost. So I think it's touch and go in the US.
Excellent. Christina, thank you very much. I'm going to come back and talk a little bit more about antitrust in a moment. If I can bring in Dido. Dido, as the chair of the Lords Communications Committee, the committee which you sit on recently wrote to UK government expressing frustration about how slow progress has been on bringing forward this legislation. What do you see as the main risks for UK media if they don't bring it forward in the next session?
Well, just to be clear, Baroness Stoll is the chair of the committee, not me. I wouldn't want anyone to think I was usurping her. I come at this having run a sort of new entrant disruptive telco for 8 years, as you know, when I was chief executive of TalkTalk, that only existed because of the sort of proactive pro-competition regulation that Ofcom brought into telecoms that Andrea is describing for the social media world. And I know exactly, I was getting sort of horrible flashbacks actually, as Andrea's describing how time-consuming any after the fact regulatory intervention ever is, and how time consuming and impossibly expensive if you're the new entrant is. The memories I have of rows of BT lawyers and millions of pounds that I didn't have to fight with them, and how actually the only way that you bring competition into these networked markets is through a pro-competition ex-ante regulatory framework. So I sort of firmly believe that we have to do that. And I think a number of the things that Andrea said should really make us worry. The fact that even the positive framework that we've set out, well, in Andrea's words, we're still years away from that having any meaningful impact on our media landscape, I think is cause for real concern. That there's no doubt that the longer we leave this, the less innovation we will have in media, and the less plurality we will have, and the closer we will edge towards a society where the media isn't able to do what we all actually take for granted in the UK. So I think this is quite a burning platform, and because it's deeply technical, and we're all sort of speaking in long sentences to try and avoid talking about ex ante versus ex post regulation because of how technical it is. It's not front page news, and yet actually it drives what you see on the front page news over a period of time. So I think this is something that's properly serious. The big tech companies have for a very, very long time been telling us that you can only act globally in this, but actually we've learned that's not true. We've learned that you can reach a global consensus through a part of the world acting first. That's what's happened with GDPR. It's what's happening now with online safety. And I worry that if the UK, having set out, as Christina said, I think a really very positive, sensible, pragmatic way forward, we lose that first mover advantage, and the sort of terms of trade get set by a less attractive, less pragmatic, less effective system in Europe or the US. And so I think that if we want to continue to be the leaders in this space, we need the government to really move faster, and we can't afford to wait. And every month that we don't introduce this legislation, we risk that actually the whole world shifts to a framework that is suboptimal.
Thank you. I want to move on to Matt from The Guardian. Matt, you've got readers across many English-speaking markets, UK, US and Australia, where you're investing in journalism. Just how important are platforms like Google and Facebook for your business, and why does improved competition actually matter for you?
Thanks, Andy. Well, I think it's important to, I suppose, divide between the internet and the platforms. Because for our business, the internet has been revolutionary in terms of enabling us to grow from being a Manchester newspaper in 1821 to having readers all over the world. And through the internet, we're able to serve relevant online advertising and to conduct low friction payments with readers from any country. And that's a real boon for us. And we'll see, as it's already seen us reach a million digital subscribers, and we hope to grow that further. But ultimately, we know that consumers don't just read the news from The Guardian or just download the Guardian app. They read their news on Facebook, or they get their news from Google or through aggregated apps on Apple News. So the reality is that we want to connect with the widest possible audience and be where consumers are. And that, I think, matches with the policy ambition of making sure that we maintain an open and plural news ecosystem and make sure that as many news brands are out there and available to people to read. I think the challenges and what we've seen over time is that when dealing with the platforms, we've seen their policies evolve to make it much harder for publishers and developers to actually know who their business and retail customers are. And we've seen steps by them to prioritize their own consumer products and business services over those of potential rivals, which could create potential competition, greater competition on those platforms. So they have, in the words of the Australian competition regulator, become unavoidable trading partners, both for consumers and for businesses. And as a result of that position, they're able to set the rules of the game, often without negotiation, in ways that invariably benefit them and their financial interests. And just to give you a sense of kind of how that impacts, you have a situation where Facebook's allowed to impose take it or leave it terms on consumers, which to exploit their personal data for targeting in ways that no consumer would rationally allow. That gives Facebook a massive targeting capability that distorts the online advertising market away from the open web and towards their closed platform. You've got a situation where Apple is allowed to charge a £3 toll for every £10 earned through the iOS store, compared to vendors on the open web charging 1 penny for every £10 that's processed on an open website. And you've got a situation this year where the cost of online advertising on those platforms is expected to rise by 108% on Google and YouTube, and by 89% on Facebook. And it's often the case that digital competition is seen as some kind of abstract issue, but those are actually prices and kind of levels of inflation that are felt by consumers. You know, there will be higher prices at the tills, or there'll be less investment in products and services that they rely on. And it's you know, there's a lot of the previous speakers have spoken about the need to move quickly, and I really do think there is the case to move very quickly and the need for action now. There is a looming crisis in the kind of the way that the internet is funded at the moment. Many of the products that we use today online are funded by online advertising. We're lucky in the sense that we've diversified away from that and towards kind of reader revenues. Over the next 2 years, the online ad market is going to undergo fundamental disruption, and all the fuel that powers the market at the moment, the kind of third-party cookies and the technology that publishers have relied on, that's all going to change as a result of changes to technology and also the impact of legislation. So those kind of same publishers and developers that you use today to use services, they're going to have to find new ways to fund those services. And they're faced with a situation where they have a series of online platforms that are distorting these markets, that are taking extremely high tolls that will impact on the ability to continue funding and running those services. So we really do need to look at those. How do we reform the market and make sure those intermediaries are not taking a huge bite of any revenues that are generated?
Matt, I want to come back to you in a second and just talk about specifically your experiences in Australia and some of the changes there. But if I may, I just want to bring in Paul from the BBC.
Yeah.
Paul, you know, the BBC's got a long history of innovation, of embracing new technologies. What is it in your view on you know, particularly around the rise of disruptive technologies like voice assistants, and what challenges do you think they present for media owners like Matt at The Guardian?
Sure, look, and thanks very much, Andy, and thanks for inviting me today. I mean, I think it probably goes without saying that I think we think that the regulatory framework must keep pace with technological change, and actually some of the things that sort of Andrea described about the framework that's envisaged is something that we've really supported. So that idea that a framework that is flexible enough to keep up with technological change, but also has teeth to allow the regulator to act. So I think in that sort of macro sense, we think that we're sort of in the right territory. And I thought I might just talk about a couple of sort of real world examples from the BBC that shows how that technological development and how that then affects our relationships with platforms and our ability to sort of deliver our public mission, and how that's changed and why we do need regulation to keep track of that. And it builds on something that Matt was saying. If we think about the iPlayer, sort of launched back in 2007, largely accessed via a web browser, unmediated, so people accessed freely. Now, 85% of viewing of the iPlayer is via a TV interface. And increasingly, those TV interfaces have operating systems that are owned and controlled by big tech. We think probably in the market at the moment, it's about 2/3 of those operating systems controlled by big tech, and that is rising. And I think what we find is that where big tech control those operating systems, they control access. And what that means is that big tech have the ability to self-preference, they have the ability to hoard data, and they have the ability to reduce attribution. And they are all things that are really damaging for the BBC and for other media organisations. Voice assistants, I think, are a really interesting example, and one that's sort of, you know, coming fast up on the rails, actually. Almost 90% of households now have access to a voice-controlled device. And I think we see that most obviously in sort of smart speakers and people using those, but voice control is increasingly being used to access television, and I think even more importantly, access services in car. And the thing that is particularly worrying about voice is it tends to be a winner takes all kind of environment. If you think about television, you have a visual interface where at least you can choose from a few different options in front of you. In voice, you ask for something and your voice assistant gives you back what they think is the thing that you should be watching or listening to. And that, to my sort of previous point about entrenching this idea that big tech can use that advantage in controlling those operating systems, means that they increasingly pick what consumers and citizens access. So I think for us, this idea that the regulation must keep up with technology is absolutely crucial. And there are some things for the BBC where we've relied on some very specific and successful regulatory interventions like prominence. But as technology develops, we find that they're sort of increasingly not as useful as they once were. So that idea that the regulation needs to be flexible and keep up, I think, is absolutely vital.
Thank you very much. I mean, very small example in my household. My 14-year-old son is an avid Capital Radio listener, and when he asks for Capital on his Google speaker, quite often gets a song played by an artist called Capital and doesn't get the radio station at all, and has spent many hours shouting at the device to try and get the right thing. And I think the reality of seeing those things is starting to come forward now. Dido, if I can come to you with a question. I mean, we get so many benefits from the platforms, and for media, they're an important distribution channel for reaching citizens as well. Is there a risk in all of this that we actually undermine innovation online if we're not careful with regulation?
I'm afraid I sort of take the absolute opposite view, which is that the way that we drive innovation online is by ensuring that there's a competitive market. It's not a particularly benign view of human nature. I think the reality is that businesses behave better when they're forced to, and they're forced to best by competition. There was a great expression that I think it was one of the founders of Skype said, who said, monopolies are like children. Until you've had one of your own, you don't realize how precious they are. But once you've got one, you will protect it with your life. And the reality is that, companies with monopolistic power will tell you that no innovation will happen unless they're allowed to retain their power. The opposite is true. What they're doing is they're protecting their baby. And actually, I think it's a huge mistake to view competition and innovation as a trade-off. Actually, it is the competitive landscape that sparks innovation. We need a burning platform as human beings to drive change.
Christina, do you think the proposed UK market reforms will make a positive difference to fair and effective competition in digital markets? Do you think it will have a negative impact on innovation?
I certainly think that the UK model is the best out there for reasons I explained earlier, and I think it has the potential for making a big difference. I'm completely in agreement with Dido. From economists' perspective, the notion that there is a trade-off between innovation and competition is an old chestnut that we have heard for many years. It has been part of the lobbying message of the platforms themselves. Ever since I worked so many years ago on the Microsoft case, you heard that if the government intervened and touched them, this was going to be the end of all times in innovation, and the rest is history. So this is emphatically not true. But it is also true that I think, as well as the current measures, the notion that somehow we need to price open and to contain the platform, I think we need to go and look beyond that still, because I think what has happened, and some of the previous panelists alluded to it, has been that the internet, which was an open experience, has become closed, the protocols have become proprietary, and they've become centralized. And this is really the issue now. We are looking at something which is being concentrated and centralized in ways that are beyond our imagination, and the notion that we can try with regulation to prize open a few doors is attractive. We can try. I think we need to think more seriously and continue to think about how we decentralize the internet going forward. The discussion now has moved on from regulation. It's about Web3. It's about how do we actually decentralize this, and the answer is in crypto. But if we let it not go the right way, it might just be as crazy as crypto. So I think we need to just see that there's a lot going on, and the reforms have got potential. But for all the reasons I kind of mentioned before, these companies are not waiting in their boots saying, oh, gee, I'm so scared, I'm so scared. They're not going anywhere unless there is a way in which we can decentralize the internet more.
Christina, thank you. Paul, we can just come back to you. Do you think the forthcoming competition regime is going to be flexible enough to address these evolving technologies that you spoke about in the future?
I think I'm going to answer that in a sort of, I think we have to believe that it will and that it can be. So I do agree with Christina that I think we've all spoken about how complex this is and about the difficulty of the problem that we're trying to solve. So I don't think we believe that there is a simple solution, but I think we do think that actually the UK is on the right track. We do think that the UK government is taking a leading role. I guess maybe to sort of echo Dido's point is we now really want them to get on with it. And I think in some ways we've got to get going and we've got to have a go. This is going to be hard. I think we've got the right framework, but sort of now's the moment to press ahead and to try and make that difference. And that idea that if we don't, I think we're just going to see these harmful behaviours, the strength of these companies entrenched further. So I think sort of now is the moment.
Thank you. Matt, I touched on earlier your experience of the Australian news bargaining code with Facebook pulling news from their platforms. What have we learned there? The Guardian, a provider of news in Australia, what's been your experiences?
So I think, contrary to the views of some platforms, the licensing of journalism is a common practice. It's existed for, I would imagine, centuries, although I wasn't there. Certainly the licensing of journalism digitally happens every day. We have contracts in place with incumbents such as Microsoft and Yahoo, through to new news aggregators like Smart News. And they all pay because they see the value of using journalism in ways that are good for their business. Now, until the Australian code was mooted, the largest platforms, the largest users of journalism, weren't prepared to enter into negotiations with publishers to have discussions about commercial use of that content. Australia did change that, and if you compare the discussions that we had in Australia with those that we've had in the UK and in other territories, you're seeing multiples of value on the table in Australia compared to those in the UK. And I think the other big difference is that, for years we've had grants that have been given by online platforms with lots of strings attached, lots of form filling, lots of kind of prescriptive elements of how you use that money. The Australia process was different in the sense that money was given to publishers as licensing revenue, and then they were able to use that to innovate in ways that they chose. So they were able to build products and services that they thought their audience wanted, and to use that to build towards their strategy. And that is a huge difference and a big change in mindset in the way that money is given.
Thank you. That's a really sort of helpful insight onto sort of experiences with markets where we might slightly be ahead. Andrew, if I can come back to you, I mean, you spent considerable time, effort, resource to prepare the CMA's digital market unit for this new regime. I think you've also made a very strong case to government on why it's needed. We don't have clarity on when they're going to bring it forward, whether it be in the next session of Parliament. I mean, you've announced you're stepping down in the summer as CEO. Are you concerned or hopeful for the future pro-competition regime?
I mean, ideally, clearly, I would like to be in a different place. I mean, I think the experience, if you think about financial services regulation post 2008 as an analogy, it was a massive piece of work. It was super complicated at all levels, in the US and here and in the EU. There was a very strong, political push for it, and parliaments spent a lot of time on it, regulators. So it was a 2, 3, 4 year period where kind of everyone was pushing in the right direction. Now, you can agree or disagree with specific pieces, but clearly that regulation has clearly helped. So I think we should be in a similar place here. There should be a sense of, I think as Dido was saying, it's a burning platform. It's really worrisome in terms of media, in terms of democracy, in terms of a number of things. But I think, as you said, it's quite hard. And I see it in my daily interactions, and I'm sure you all see it in interactions with your constituents. It's so complicated. A lot of these things are just behind the daily experience of users. everything is based on algorithms, but people don't see algorithms, don't think about algorithms. And so I think it requires a significant collective push by government, by parliament, by people like us to explain why it's important. I think there is now a consensus that broadly this is, and I think the panel today has been excellent in that. I think there's consensus that broadly this is the right recipe. I mean, obviously we're going to spend a lot of time discussing the details, but I think it's really important that we get on and do it and course correct over time. I think, again, we have experience from regulation in other sectors how to do it. So I mean, I think I see my role as, you know, explaining it, being out there, explaining it the same way as you and others do. I think, again, history shows that over time, if you have the right ideas, that these things happen. It's just difficult to predict exactly when and how. And, you know, at the end of the day, from my conversations with government, I don't get the sense that the government is in disagreement with it. I get the sense it's just a question now of political priorities across a number of areas. And obviously that's not my job, it's your job and the job of others to kind of rank those things. I mean, clearly from where I sit, I think it's a priority. I think it should be part of the third session and it should move on. But clearly it's not, I mean, I can only advocate and explain these, and someone else is going to make that decision.
I think that's a very good answer. I must say, I'm very grateful for the panel's views on this. Dido, I wonder if I can just come back to you. I mean, you've done a tremendous amount of work during your time at Talk in particular around sort of online harms and tackling some of those challenges. I wonder, you know, if we can just sort of pick up on that a little bit as well. You know, you've previously spoken about why digital regulation to promote competition and innovation is important for online safety. Just expand on that a little bit.
Yeah, of course. And I think Lord Lipsey's posted in the chat, one of the sort of perceived challenges for sort of getting this legislation through is the priority that we as a country have given to the online safety bill. And I think we mustn't view this as a trade-off, that actually the more competitive these markets are, the more likely the participants are to actually listen to their citizens, their users and their families to tailor their products to meet their needs. You know, that's one of the, you know, it's actually a market failure that our social media platforms are not addressing online internet safety properly. So I think you have to look at them together, and I think that we should resist the temptation to solve the problems sequentially.
Have you had any indication from your conversations with the government around what's likely to come in the next session of Parliament?
I would love to say that I know, but that is well above my pay grade.
Always worth asking. I want to say thank you to the panel, to Andrea Corselli in particular for the introduction statement that you made, to Dido, to Christina, to Matt, and to Paul as well. It's been a really fascinating session. Very grateful for thoughts that are coming in. We've got a couple of seconds left. If anybody wants to put any questions into the chat, I'm very happy to pick them up. I see one's just come in there from Katerina. Amazon hasn't been mentioned specifically today, but raises the same type of issues for publishers as those mentioned. You know, anybody want to pick up on the sort of the Amazon issue? I don't know whether Andrea, you might want to pick up on this, or Paul, if you want to just pick up on that.
Yes, thanks, Andy. So I think Amazon is firmly in that group of big tech companies. I mean, interestingly, differently from Google and Facebook, in the sense there's been more organic growth as opposed to particular acquisitions that were problematic in the past. The complaints we receive are about those issues with terms of publishers, but also quite a lot increasingly about just businesses, you know, up and down the country. I mean, Amazon Marketplace is critical for a number of businesses. And now, interestingly, there is quite a lot of activity in the EU. Some of it predated the EU exit. So some of what is happening in Europe might then have a direct impact for us and for UK consumers. Is, for instance, the conclusion of those cases has a direct read across to the UK. But generally, you know, we think, as Christina said, it's really important to have this company-specific code of conduct, and so we would certainly expect to have one for Amazon addressing these issues if we got the powers we're asking for.
Okay, thank you, Paul. Is there anything you wanted to add to your experience of sort of dealing with Amazon as a broadcaster?
Yeah, and I think maybe it's a particular one for the BBC, and it's good to hear sort of Andrea sort of say that he considers them to be sort of squarely in scope. But I think we certainly noticed with that Amazon some of the behaviours that some of the others have mentioned in relation to their business models and other companies. You sort of only have to look at their sort of the TV interface that they've been developing in Amazon Fire, where we struggle to get BBC prominent within that interface, and the BBC and other PSBs being downgraded, and some of the things that I talked about in sort of voice assistants, the way that Amazon install sort of by default their own services, the way that they self-preference in using their voice assistant, clearly causes problems for us and for sort of getting our content to users and giving people a fair choice. So look, as we've all sort of said, these companies provide amazing technology and services, and are sort of, you know, and really important in some ways for consumers and for citizens in getting our content. But it must be done fairly, and it must be done in a way that allows a sort of a plural environment to thrive. So, but yeah, I think Amazon absolutely must be part of that picture.
And do you envisage the DMU regime being flexible enough to address the sort of issues that you're talking about?
I mean, I'm going to say yes and hope that Andrea agrees with me.
I agree. I think it would definitely be the intention.
Excellent, thank you. I'm going to draw the session to a close. Thank you very much to our panelists. Really interesting session. I have to close it by reminding everybody that you can sign up to our bi-monthly newsletter via the group's website, and you can also follow the APPG on social media channels. We are going to make this this session available online as well, and we're very keen to hear from people involved in the sector with blog content to share with parliamentarians as well. So please, you know, if you have got some further views that you'd like to share on some of the issues that we've touched on today, please do get in touch with the APPG, because it is a great route to getting the message out to parliamentarians. Andrea, Dido, Christina, Paul and Matt, thank you very much indeed. Thank you to the people that have joined us online as well, and we look forward to seeing you again soon at the next APPG.
Great, thank you all.
Very much. Bye-bye.
Thanks, bye-bye.